I want to tell you about a claim involving a tax matter that's an excellent example of the need to think through whether a firm precedent will actually accomplish the client's goal. It's also a good news story in the sense that we were able to fix the problem to everyone's satisfaction. The facts aren't unusual in the tax context. The shares of a family company built up by mom and dad, we'll call it ABC Co., were left to their children. The children sought tax planning advice to ensure that the growth in ABC would be treated tax effectively. In a nutshell, the plan called for each of the siblings to incorporate a holding company and to create a family trust. Each sibling would be the trustee of the family trust, and their children, mom and dad's grandchildren, would be the beneficiaries. So the family trust would hold the shares in the holding company, which would in turn hold the growth shares in ABC Co. In that way, growth in the family company would accrue to the trust via the holding companies. It was a critical aspect of the plan that in addition to maintaining control, the siblings could be added as beneficiaries to the trust themselves if they chose to do so. So the plan was put in place. Flash forward a few years to when ABC sold substantial assets and management of the company decided to declare a dividend. It's at that point that each of the siblings decided they wanted to be added as beneficiaries of their respective trusts in order to participate in the flow of funds through the holding company to the trust. That's when the problem came to light. It turns out the trust deed contained no power to add anyone to the class of beneficiaries or to modify the trust at all. The matter was reported to us, and the immediate question was, what can we do? Can we fix this? Two options were identified. The first was to seek rectification of the trust by court order, and the second was to consider the creation of a series of sub-trusts. For a number of reasons, our tax repair counsel recommended the non-rectification route in the particular circumstances of this case. So the assets of each trust were appointed to a sub-trust on substantially the same terms as the original trust deed, but with the inclusion of language permitting the addition of individuals to the class of beneficiaries, including siblings. While the tax plan and the repair were much more complicated than this, of course, the lesson is a simple one. The stress to the insured, and more particularly to the client, as well as the cost of the repair, could all have been avoided if the lawyer who implemented the plan had considered whether the precedent she was about to use actually accommodated or frustrated the client's objectives. In this case, one size didn't fit all.